So on this case, we have a couple of cases that are awaiting indictment.
Yes.
So where are we on discovery?
Um,
And are you on all the
we're,
cases?
we're missing a dash cam, so it's not extensive.
Okay.
But what we want to do is see about a drug court referral.
Mhm.
I think it'd benefit from that.
All right. So with regards to the drug court referrals,
Mm-hmm.
I received an email from them.
Oh,
They're at capacity,
what does that mean?
that they don't have any room because they don't have enough personnel to add more people. So,
Does that mean it's shut down or do we wait?
oh no, it's not shut down. It's just,
No, I mean
Yes.
for new admissions.
oh, there will be a waiting list.
What do you recommend we do?
Well, he has to be on probation to go to felony drug court anyway. Let me ask you this. If you're drug tested, what would the results be? And you need to be honest because we're not on the record. You're not under oath. So it's not going to be held against you because you're not under oath, right? So I'm trying to figure out what way to best help you. And what I can tell you in this court, normally, if there's some type of plea bargain agreement, and I think it's appropriate, my goal is for people to be rehabilitated when they're on probation. So back to my question.
5:30.
All right, and what for? And what else?
Okay.
All right. So do you live at home with anybody or are you by yourself? All right. So one, don't use drugs in your parents' house, okay? Don't smell like marijuana in your parents' house because your parents love you, right? So what I want you to do for me, and hopefully you'll start doing it for yourself, I want you to do some sober support meetings. That will go a long way in making me see that you're on the right track, all right? What I can tell you is they have lifetime recovery, but there's an issue with funding. So
Another problem.
yes, so he'd have to pay for that. But I learned about a new place that maybe you want to look into.
What's the name of that, Judge?
It's called SOBA.
Sofa?
Yeah, SOBA.
Soba.
Yes. And
Probably sobriety something.
let me see what no, they just call it SOBA, Texas Drug Rehab, Detox and Addiction Recovery.
Texas.
So of
Rehab,
course it's
okay.
on a ranch. But you may want to look in it. They do have some testimonials, but you know how that is. But they do have addiction services there. They do have inpatient there. Let me give you the number that appears on this. It's 210-529-8410.
Okay.
And I will give you this, but I don't have an extra copy of it.
I don't, is it like a handbook or something? No, this is enough. We're okay.
Okay.
We'll get on their website.
All right. So make sure that you do sober support meetings, all right?
Sure.
And for you, because you came to court, you're going to be positive, and you knew you were coming to court, that means that you have a major problem. So I want you to do daily sober support meetings. They're located throughout San Antonio, throughout Texas. They're available all hours of the day.
You're talking about NA.
Well, yes, but they call them sober support meetings now, but NA. So do one a day. Now, if you feel you need to do 2 a day, 3 a day, then do that. But I'm trying to make sure that you get clean and sober, all right? So starting today, do a sober support meeting, listen to people, talk things out, because sometimes it helps when you see people who are in the same predicament that you're in, or either you see someone who was where you were and now they're in a better place, okay? All right, so we have the body cam. Or dash cam.
Dash cam.
All right, so State, if you can make sure they get the dash cam. All right, is there anything else?
No, can we get a date?
All right, if I can have 30 days for discovery, please. All right, June 9th.
6/9.
Yes,
Well, thank you, Judge, as always.
sure. And I'll still do a referral to felony drug court. they won't be able to move on anything unless you're on probation. And also they'll probably put you on a waiting list, but at least you'll be closer to the top of the waiting list.
Let's hope NA starts to kick in, well, daily, what did you call it?
Daily sober support meetings. All right, so make sure you do those, all right? And thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you'll be excused.
Thank you, Judge.
You're welcome. Have a good one. And Norma, do a referral for felony drug court. Who is here on Havana Miller? All right. Who is is this a special prosecutor on this? All right. State, did you make an offer?
Yes.
And how old are you? All right, Ms. Ferguson, set this for 3 weeks for a plea deadline date, please. June 5th. On that date, you need to let the court know whether or not you're accepting the state's offer. You've reached an agreement. If you have not reached an agreement, your next court date is going to be a jury trial date. Do you understand? All right, thank you for dressing it appropriately for court. Just have a seat and your attorney will bring you a reset form. Once you sign the reset, you're excused. All right, and has the acknowledgement of discovery been completed?
Yes, it was turned in at the last setting.
All right, thank you.
Uh-huh.
Hello, how are you doing this morning?
Fine.
All right. So who is the prosecutor on this case?
All
All right, thank you. So is all the discovery completed
Yes, sir.
and an offer tender?
Yes, sir.
All right, thanks, Dave. All right, how old are you? All right, so what I'm going to do is I'm going to set this in 3 weeks, and in 3 weeks' time, you'll need to let the court know whether you've reached an agreement with the state. If an agreement has not been reached, your next court date is going to be a jury trial setting. You understand? And counsel, if it's going to be a jury trial setting, if you all can already discuss whether she wants a bench trial or a jury trial.
Yes, Judge.
All right, I need a 3-week reset. Yes. All right, June 5th, okay? And what I can tell you, if you decide to proceed with a bench trial, if you come to me, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. So if you come to me for a bench trial, I'm just going to listen to the evidence and make a decision based upon what I hear, all right? All right, so we'll be back on June 5th. On that date, you'll need to let me know whether or not you've reached an agreement with the state, okay? All right, and thank you for dressing appropriately for court. Have a great rest of your day. All right, so if you'll let her sign the reset form, then she's excused.
Yes, Judge.
All right, thank you. All right, who's here on Marco Antonio Marino Vasquez? All right, thank you. So counsel, do you have all discovery now?
I do. We've gone through it. The state had recently given me some new discovery. I've gone through with my client. He also provided videos, which I've gone through that I don't think my client needs to see, but they are potential Brady that we can use later if we need. So I think we need a trial date.
Yes, we do. Does he want a jury trial or a bench trial?
Jury trial.
With the jury. All right. All right, how long do y'all expect this trial to last?
I would say at least a week.
I would think so.
There's a few videos. in it.
Oh, okay.
I mean, it has security surveillance that might be a little bit longer than the normal.
All right, if you all will speak with Ms. Ferguson on a jury trial date and then come back to me with the date that you all agreed upon. Do
Thanks.
you have any questions, sir?
And we did,
No, thank you.
We've sort of narrowed it down, Judge.
Judge, I mean, just looking at our schedule, the only dates that I see that if it's one of this year
Everyone, please whisper.
would be December, the Monday's the 8th, but December 9th is a Tuesday. That's, I mean, because everything else sort of has,
It's booked.
well, yes, Your Honor, unless you want to get it to January, then that's
No,
entirely up to you.
All right, this is what we'll do then. Mr. Marino, in this court, We're in trial every week. I don't like for people to have to wait for their jury trial. But the state can only try one case at a time. And I try to make sure that trials are placed on the docket as quickly as possible. The earliest date that we can give you is December 9th. Now, if for some reason there is an opening that opens up sooner, we can let your attorney know and we can have you brought over sooner. Do you have any objections to the December 9th date?
Pues entre más rápido es mejor.
Well, for me, the sooner the better.
All right, let's go on the record.
Porque
Court is calling 2023 CR 4371B State versus Marco Antonio Marino Vasquez. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
For the
David A.
defense?
Garcia, attorney for Marco Moreno Vasquez.
And are you Mr. Marino Vasquez?
Yes,
All right, if I can have the interpreter, if you can raise your right hand. Do you solemnly swear or affirm do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. So, as I was stating off the record, Mr. Vasquez, we try to get cases set in jury trial as quickly as possible. If I had 20 prosecutors in this courtroom, we could still only do one jury trial a week because I have other cases that I have to attend to as well. I know your case has been on the docket since July of 2024. There have been several issues that are outside. Oh, excuse me, just one second. Are you the first attorney on this case?
I am judge, but there have been a lot of discoveries that have come in over time. And I think that's one of the reasons why things have been delayed.
And just for the discovery purposes, the CPS information just became relevant or actually given notice to us and actually just developed in probably the last couple months or so. And then he does have a co-defendant that was set before him that ended up fleeing and he's pending sentencing. So that may have complicated issues.
Okay,
So that might be something.
all right, because I'm looking at the time that he's been on the docket and he's actually been on the docket for what I consider to be a long time, but now that has cleared that up.
Right. And then I think one other thing was it came in as tampering
Mhm.
as opposed to the murder.
And and it's still listed.
Right, it's still listed as tampering, and that was one of the issues that I had to contend with my client, because he kept arguing that he's only charged with tampering. And I was like, no, there's also a murder.
Well, and actually, I believe, my understanding is that it's a 3-count indictment. It's murder and tampering and also, I believe, deadly conduct or something like that.
Yes, and then there's a burglary of a habitation. Well, no, there's a discharging of a firearm at a habitation. So, sir, you actually have 3 counts in your indictment. You have a murder count, you have a discharging of a firearm into a habitation, and then
The tampering.
and a tampering.
May I speak?
Sure.
Es lo que no entiendo yo eso, porque desde los primeros 3 meses que me llegó el andamio, tenía yo el caso de muerte. Después desapareció y me pusieron tempo whatever. Por más de decisión.
All right.
That's what I don't understand. In the last 3 months, they told me that they gave me the indictment and it showed the murder, but then it was the tampering.
All right, so let me just explain something to you. When they do an indictment, the court receives one and the court receives the original that's signed by the foreman of the grand jury. So this is your indictment and there are 3 counts in it. Now, sometimes what will end up happening for some reason, when a case is indicted instead of the higher level felony being listed first, they list the lower felony. And then people will think, oh, I'm just charged with a third degree felony tampering with evidence. But there are other counts in it. So whenever you see something, when they bring you over from the jail and what you're charged with, they don't list all 3 counts that are in your indictment. They'll just list one offense. And so in your case, that's why I always get confused when I see you, because in your case, on the court's docket sheet, it'll just say tampering with evidence. That's why I was looking at both of them. How can a tampering with an evidence case take 5 days or a week? But then when I go back and I remember and I look at your indictment, and one count, you're charged with murder, and another count, you're charged with discharging a firearm at a habitation, which means a place that's occupied and somebody's living. And then the third one is tampering with the evidence. So when they indicted you, they just took one general case. And they, under that one case number, they put all 3 counts. If they wanted to, they could have said, you know what, we're going to charge him in 3 separate cases. You have 3 separate cause numbers. One cause number will be the murder case. One cause number will be the discharging at a habitation, and the other one will be tampering with evidence. But they just decided to put it all in one indictment. Do you understand?
Sí.
Yes,
Ahora le pido por favor.
I ask you, please.
Por eso ya tengo más de 1 año y medio diciéndole al abogado que quiero ir a juicio.
It's been more than a year and a half that I've been telling my attorney that I want to go to trial.
Porque lo que por eso quiero ir a juicio para que el jurado me escuche y también la juez me escuche, porque aquí no me dejan hablar cuando yo vengo.
That's why I want to go to trial, in order for the judge to listen to me, the jury to listen to me, because when I come here, nobody allows me to speak.
Y luego, para los que me están acusando de muerte, que me están acusando que le disparé a una habitación, y lo otro, por eso quiero que me enseñen las pruebas de que tengo, porque yo sé que yo tengo mi mente limpia, que yo no hice nada. Quiero que me enseñen.
And then they're telling me that, there's the case of murder and then the discharge of a firearm. So what I want is for, to be able to see all the proof and everything that they have.
All right, so let me explain something to you. Sometimes the length of time that it takes you to go to trial is outside your attorney's control. The way I say we can't do 2 cases at the same time for jury trial, we came close one time. We had a jury deliberating and started another trial. But your attorney can't be in 2 places at the same time. And I guarantee you, Mr. Garcia, I know him. He's never been to my house for dinner, so I don't know him that way. But what I can tell you is, I know for a fact that he's been in a jury trial since your case was pending. And if he's in a jury trial somewhere else, he can't be in a jury trial here, because nobody can be in 2 places at the same time. And then when we're in a jury trial, we can't have your trial. So then your case will get pushed back to another day. So the fact that this is your setting day is not your attorney's fault. It's not my fault. It's not the state's fault. It's just that your case is not the only case on his docket, on the state's docket, and my docket. If your case were the only case that was pending in all of the cases that I have, and I think I have over 1,000 or something, we would try your case right now. Today, I would bring a jury in, but that's not what we have. Now, with regards to your viewing the evidence, I've been a defense attorney, I've been a prosecutor. What I can tell you is sometimes people, when they're charged with a case, they don't look at their evidence objectively. They want something, and they want their attorney to tell them something different than what they're seeing. Your attorney can show you the evidence, you look at it, and then you make an informed decision on whether or not you want to go to trial, or whether or not you want to reach an agreement with the state. I will tell you what I tell everyone here. I've had people come to me before bench trials. I found some people not guilty. I found some people guilty. Whatever evidence is presented to me, this is a murder case. For me, I would listen to the evidence, and I'll base my decision on the evidence that presented to me. I'm not going to say, oh, the state didn't prove their case, but this is a murder case. Let me find somebody guilty. For me, it's a murder case. Did the state prove their case beyond a reasonable doubt? Even on a murder case, if they didn't prove their case beyond a reasonable doubt, I'm going to find you not guilty. If they prove it beyond a reasonable doubt, I'm going to find you guilty. Do you understand?
Yes,
Now, if you want a bench trial, I can get you in here sooner. But in order for you to be entitled to have a bench trial, the state has agreed to waive the jury, and you have to agree to waive the jury. So if you want a bench trial, then we can do it sooner. If you want a jury trial, the earliest I can have you in here is that December 9th date. If something falls through, the state can call your attorney, the coordinator will call your attorney and say, we have an earlier date open. Do you understand?
entiendo.
Ah,
Ajá.
yo no le estoy echando la culpa a ellos de que el juicio, ¿cómo se llama? Que se está tardando nada de eso.
I'm not
Simplemente
blaming them
yo no le-
that the trial is taking long or anything.
Yo no me estoy guiando a lo que ellos me están diciendo, que me dicen que una fecha y luego otra y otra y yo estoy esperando.
I'm basing myself on what they're telling me. You know, they give me one day, they give me another day, they give me another day. You know what I mean?
The reason why is because when you are given a jury trial date, if there's a case that is older than yours, that is on the docket as well, then that case will go first. In your case, you had a co-defendant. The co-defendant decided to enter into a plea. So once he or she entered into a plea, then your case became next. Your number ends in the letter B. So the person whose number ends in the letter A goes before you.
Okay,
Y otra, no es porque no,
Thank you,
no,
baby,
quiera ir
excuse.
nada, simplemente que en más de 27 meses no me lo he visto 2 veces por aquí nomás.
well, and the thing is, not that I don't like him or anything, but in the 27 months, I've only seen him like twice.
All right, so here's the thing. Let me just tell you another thing. Sometimes defendants want to see their attorneys. They would love to see them on a daily basis because I know this is an extremely important case to you, right? But
Uh-huh.
some attorneys, if they don't have any new information to give you, their whole thing is, why am I seeing you? I don't have any information to give you. I'm going to show up and say, hey, we're waiting on this discovery. I don't have it yet. Now, I will tell you, when I was a defense attorney and I was starting out, and this is how you get burned out, I would see, if I had a client in jail, I would see them once a week. I would take the via bus, go to the jail, and I would see my clients on Saturdays and Sundays. And I would come and I would tell them, hey, I'm just letting you know that I'm still working on your case. I'm still waiting on this. Because sometimes the only visitor that your client will have is their attorney. Now, I would do that. I didn't have to do that. And your attorney doesn't have to do that. If they don't have any new information to impart to you, there really is no reason for them to see you. Because at the end of the day, in the words of John Wayne, we're not here to make friends. We're just here to do a job. Right?
Uh-huh.
So that's where we are. Now you're saying you haven't seen something.
See something?
He said he hadn't seen what the state has against him.
Nomás me enseñaron un video que tienen contra mía, que según estuve presente, y es lo que he visto yo nomás. De
The
100,
only thing I've seen is a video that they showed me where I was supposed to be there. That's all I've seen.
de 100 videos que trae el investigador, nomás me han enseñado
So
uno.
let me ask you this.
The 100 videos that the investigator has, they only showed me once.
All right, so here's the thing. My question is, have you seen the police report?
Ah, no me enseñó nada.
They have not shown me anything.
All right, so Mr. Garcia, I understand what's going on. But if you could just grab the state's file and let him read the police report.
I'll do it again, Judge. I've done it in court
I know
many
you have.
times. My investigator spent countless, I mean, a lot of hours showing him tons of video, reading him all of the reports. My investigator speaks Spanish perfectly, and that's why we have that done so that there's no problem. It's much harder here in the court, but I'll go through it again.
All right, so they're gonna go over the police reports with you again. It's gonna be whatever is in the state's file, and your attorney will look at that. And after looking at that, if you change your mind about anything, just let the court know. But your court date is going to be December 9th.
Thank you, Judge.
Gracias.
Muchas gracias.
Yes, thank you very much.
De nada. That's all I know, really.
Here's a copy of the-
Yo tengo uno, yo
I have
tengo como
one.
All right, if you'll come forward. Probation, this is an application. All right, counsel, you on this side. Court is calling 2025 CR 003649, State versus David Wayne Huff. Can I have parties announce?
Matthew finished for David Huff, Your Honor, ready.
And are you Mr. Huff?
Yes, ma'am.
Counsel, have you received all discovery?
I have, Your Honor.
Did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Mr. Huff, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do waive, Your Honor.
State, are you proceeding on the indictment as presented? All right. Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram, within 1,000 feet of a playground, and that makes it a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Huff, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. The state recommends community supervision. They will take in consideration 2025 PF 06925. Did you understand that to be the plea?
Yes, ma'am.
Defense,
Yes, Your Honor.
state,
Yes, Judge.
did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. Did you understand that's a recommendation from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plea?
No contest.
State any evidence.
State offers exhibit 1 and attachments, Judge.
We've reviewed those, Your Honor. We have no objections.
State, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, The court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we waived PSI today.
Anything you wish to say on behalf of your client?
Your Honor, my client is motivated. He's accepted responsibility today. He's asking of the court to follow this plea bargain. We would ask that you sentence him accordingly and follow our recommendations to the court as well.
All right, so how long have you been using?
About 10 years.
All right, why did you start? What happened in your life?
My mom, my dad, and my stepdad was killed in the car wreck.
I'm sorry to hear that.
Kind of messed me up, but
So are you, if you were tested today, what would the results be? All right, positive for what?
Uh,
And what else? All right, so here's the thing, where you're starting at now today. It's the court's hope that this probation, you'll improve and you'll get clean and sober and you stay clean and sober. So do you have any support system?
yes, ma'am. They want me to go to treatment.
Right, so I mean, do you have, where are you, who do you still with?
I got my own house. I stay in Asheville Road. But,
Okay, so do you live by yourself?
Yes, ma'am.
Do you have any children?
No, I got 2 kids, but they live in West Texas.
And what are their ages?
My son's 24 and my daughter's 18.
All right, do you have any grandchildren?
No, yeah.
Okay, are you working at all?
sir.
What do you do?
I work right now. I work for People Ready.
I'm sorry, what?
For People Ready as an electrician.
Okay.
So.
All right. This is what the court will do. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's to be no contact with Veronica Renee, Renee Trevino. There's to be proof of employment within 30 days. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. Field visits 1 time per month until further notice. There's going to be 200 hours of community service restitution. 120 sober meetings in 120 days. A referral to felony drug court. TAP evaluation. Out of custody. Follow TAP recommendations. Probation, is there anything else he needs? And I'm sorry, taking consideration 2025 PF 06925.
Judge, may I approach?
Yes. Is there anything else you need from the court in order to be successful?
No, ma'am. I appreciate it.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right. In this court, to be successful on probation, communication is key. So if there's an issue, talk to your probation officer. If you feel as though they're not addressing it, you can always come back to court. And nobody can help you, and we can't help you with your drug addiction if you don't want to help yourself. Now, I've ordered that you have a TAP evaluation out of custody. They're going to give you a date for that. If you miss that date, what's going to end up happening is a motion to revoke is going to be filed. You're going to be taken into custody. Either you'll make bond or you won't make bond, and I'll hear that motion to revoke. So if you need to get an appointment booklet, get an appointment booklet and put your dates down. You understand? And when you leave here today, other than following their instructions, you need to go to a sober support meeting. Those are the NA meetings, so you can get your life back on track. Because if you continue to use, only 2 things going to happen. Either you're going to end up in prison, right? And you're going to lose everything. You're going to lose your house. You're going to lose even more time with your children. or either somebody's gonna have to come down and identify your body. You understand? All right, good luck to you.
Thank you, Your Honor. May we
Thank
excuse-
you. Yes. Just have him remain in custody to speak with probation. Who is here on Roberto Avalos Jr.? And probation, there's no application. Court is calling 2024 CR 012312, State versus Roberto Avalos Jr. Can I have the parties announced?
Megan Galloway for the state.
Jimmy Callahan defense.
All right, and are you Mr. Roberto Avalos Jr.?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Avalos, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Avalos, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand,
Yes, ma'am.
counsel?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand by entering into this agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Avalos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers states one in attachments.
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Clear County District Clerk's records reflect 44 days. I think that might be slightly inaccurate because I believe he's been under arrest either in this county or in other county since August the 22nd, 2023.
All right, if you will make sure to verify that with the clerk. What I can tell you, sir, if there is any time that you've been in custody while this case has been open, you'll receive credit for that. All right, the court will find you guilty, sentence you to 6 years in the prison, give you credit for any time served. There's a $2,000 fine, time and money run concurrent. There's to be no contact with Dora, D-O-R-A, Marie, M-A-R-I-E, Bravo. Is there anything else with regards to sentencing?
No, Your Honor, but for, I believe that's I'm required under rules of ethics, the pending case is complaining, or rather the person you said he must have no contact with. I think that case is still pending in your court.
All right. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
Thank you, Judge.
You're welcome. So on this case, where are we on discovery?
Judge, I think we've gotten all the discovery and, there are just a couple of issues that we're just trying to figure out,
Okay,
and that's restitution on each case. The state's gonna need a little time just to reach out to the complainants.
all right. How much time do you need, state?
30 days.
All right, Ms. Ferguson, I need a plea deadline date for 30 days. All right, June 12th is your plea deadline date. Is there anything else?
No, Your Honor.
All right, thank you for dressing appropriate for court. Just have a seat. Once you sign the reset form, you'll be excused.
Thank you, Your Honor.
Thank you. Where are we on discovery?
I think probably we have, what we need, I would imagine, Judge. There's two issues I'd like to address with the court. One is, he was remanded without bond. My client, actually came to my office, I don't know, maybe about a month before the trial setting. He doesn't have a phone. He did leave me an email address, I think, or my office got an email address. I tried to send him an email, but it didn't go through. He didn't ever receive a letter or notice in the mail about the trial date. And so he really didn't have any notice of the setting.
All right,
And so I was
so
gonna see if we could get a bond set or get the bond
Oh,
reinstated.
you'd have to,
Yeah, I'm
Follow.
not, I'm not evading, Mama.
No.
I'm on my way.
you'd have to file a motion, and the soonest we'll be able to hear it is Monday.
Okay.
All right,
Okay, Judge. And I guess the other issue is that, I think we need to get a trial date on that if he's not gonna be able to get out.
all right, so what we'll do is we'll recall it on, Norma, recall this for Monday, the 19th. That'll be the hear your bond issue, okay?
Judge, is it possible that, is there any other day that, is it start the Monday? Or is Monday the day?
You want the 20th, the 22nd?
The 22nd would probably be better
All right,
if it's possible.
sure. Ms. Ferguson, recall this for May 22nd to hear the bond issue.
So the same.
All right, and then if you want a jury trial, you need to decide if you want a jury trial or bench.
Trial.
All right, if you want a bench trial, talk to your attorney. And then if you'll confer with the state, we can do a bench trial quickly. So just talk to the state on a date. This is a state jail, I'm assuming.
Yes.
So it shouldn't take that long.
No.
It should be done in a day.
Absolutely.
You're welcome. So just let us know when you would like that.
All right, thank you,
No,
Judge.
they're gonna be requesting a bench trial. Thank you. Have a good day. Oh, thank you. God bless you too. No, yes, for the bond hearing. And then if they can do whatever they want on the bench trial, I mean, if they wanted to. Yes. Oh, I'm sure the state will agree. Yes, and if you all want a bench trial,
Judge, the state is just gonna tell you maybe, I guess. So I don't know if that's a yes or a no.
oh, I'm sure it'll be a yes. Just figure out what date you all want your bench trial. It should be a day.
Okay.
All right, they're gonna bring your guy back from the back. My understanding is that the bondsman is on his bond. All right, so where is Lazarus
It's right here.
He's
Korea? Come down, please. Okay, my understanding that this came from another court. It's been on the docket since August 2024. So this is what we're gonna do. y'all are not seeking the death penalty, is that correct?
Correct, Your Honor.
All right. So I'm going to give you all, do you have all of the discovery? Do you know if you have all discovery?
That's what I think we're gonna have to go over, and that's why we're asking for 45 days, because of the two places, and just make sure that she's got it and that we've gotten it from her.
All right, Miss Ferguson, recall this. I'm gonna recall this for 60 days. Say, at that time, you'll need to be prepared to tender an offer to the defense.
Yes, Your Honor.
All right. All right,
What was it?
July 14th.
Okay. that's
On that
perfect.
date, what's gonna end up happening in this court, I like for things to move, for progress to be made. So on July 14th, your counsel is gonna have all the discovery. The state is gonna tender an offer. After that, you're gonna get a 30-day reset, and that's gonna be your plea deadline date. And on that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date is going to be a jury trial. And for jury trials, the court does not consider any plea bargain agreements without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right. Is there anything else?
Not from the state, Your Honor.
Nor the defense. attorney.
All right, thank you. Then the deputies will take him back.
Thank you, Judge.
You're welcome. All right, thank you. All right, who's here on Summer Mascata? So where are we on discovery?
Judge, I'm not certain, to be honest with you. As I expressed to the court yesterday, I was unaware that this case had been indicted or was set this week until I received an email from the court on Monday stating that the time that the court was having docket had changed. So as a result, I haven't had an opportunity to fully review all of the discovery. I hadn't talked to my client in over a year, Judge, so I haven't had an opportunity to discuss this case with her recently. I know I was here yesterday and there was some concern about me being able to reach her. We did get a hold of her. I do have new contact information for her, so that shouldn't be an issue. So
No,
we
she
were,
came in late yesterday, so she made it after, this is a full service court, after we used our contacts in court to reach out to her. All right, Ms. Ferguson, I need a 30-day reset on this date. State you need to be prepared to tender an offer.
Yes, Your Honor.
All right, June 12th,
great, thank you, Judge. May we be excused?
after she signs the reset form.
Thank you, Judge.
All right, thank you. All right, counsel, where are we on discovery? Have you received it?
Yes, Your Honor, I have.
And that's okay. State, were you able to tender an offer?
Yes, Judge.
All right, sir, how old are you?
54.
All right, Ms. Ferguson, if you'll set this in 2 weeks for a plea deadline date, please. All right, we'll be back on May 29th. At that time, you need to let the court know whether or not you've reached an agreement. If you have not reached an agreement by that time, your next court date will be a jury trial date. Thank you for addressing appropriate for court. Once you sign the reset form, you're excused.
Thank you.
Thank you, man.
All right, good seeing you. All right, just give me a moment, please. All right, who's here on Eduardo Hernandez III? And after that, it will be Brandon Bowman. And probation, this is an application for deferred. Court is calling 2025 CR 004-104. State versus Eduardo Hernandez III. Can I have parties announced?
Rick Pena for the state of Texas.
Doug Campbell for Mr. Hernandez.
All right, if y'all could not talk behind the court reporter while we're on the record. And are you Mr. Hernandez?
Yes.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Mr. Hernandez, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Hernandez, did you review the court's admonishments with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with injury to a child or elderly or disabled person bodily injury as a third-degree felony Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? You need to speak up.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Excuse me, miss. If you cannot whisper, then you need to stop talking. We're on the record. All right. Are you a U.S. citizen?
Yes.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 CR 003443. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of the plea?
Yes, ma'am.
Defense is at the plea?
It is.
State is at the plea.
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be 80 hours of community service restitution, a MIC evaluation, follow the recommendations from MIC, a TAP evaluation, follow all recommendations in anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor, this side state offers into evidence State Exhibit 1 with all attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. And state, have you spoken to the complainant?
Yes, we have, Your Honor.
All right. And then the complainant's name is listed with the last name of Garza in the police reports. But in the plea bargain agreement, you've put it as Hernandez. Well, actually, they have two. They have one that's Hernandez and one that's Garza. And they have two completely different birth dates. So I'm assuming it's no contact with both. Because one is listed as January, one is listed as October
I think it's.
in the stipulations.
It is Garza. It should be Garza with the January 10th, 1959.
Okay,
I think the other one might be a typo.
all right. Love typo, gotta love typos. All right, thank you, State. You may be excused. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Mr. Hernandez is going to be homeless because of this incident. While he wants to take responsibility and get this behind him, he's not gonna have a job, he's not gonna have any money. He would like some assistance in finding a house, but if that's possible to any of the services the court might have available to it. He also would like to have it probated, the fine, and he'd like to do his evaluations while out in the world.
All right, so why didn't you clean up your mess in the kitchen? Yeah, that's what it says. It said they told you to clean up your mess in the kitchen. You became upset and said something bad was going to happen and you will not like it. That's what you told the complainant. So how old are you?
I am 39.
Why are you living with your parents anyway?
I got kicked out of my other parents' house. And I lost my job too.
All right, so why did the other parent kick you out of their house?
They got upset. They're arguing about something about a bowl. That's my boss. It's just
Something about what?
a bowl, a cereal bowl.
Mhm.
And they're in that an argument.
All right, so here's the thing. You're an adult. You shouldn't be going from parents' house to parents' house. And I'm going to tell you what I tell everybody who is an adult or living with somebody else. If you want to keep a dirty kitchen, you can keep a dirty kitchen. But guess what? It needs to be your dirty kitchen. So whether you're an adult or not, whether you're 21 or 60, if you're living under somebody else's roof, you need to follow their rules. You understand? They're asking for a MIC evaluation. Is there any prior mental health issues?
That's my nephew.
I'm sorry?
He has physical deformity, Judge. He can't hear out of his left ear.
Oh, okay.
So you might have to speak up a little.
All right. They're asking for mental health evaluation. Have you ever had any mental health diagnosis?
No.
All right. So do you have any children?
No.
This is what the court is going to do. 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, taking consideration 2025 CR 003443, $1,500 fine, probated, affirmative finding of family violence. There's to be no contact with the complainant and no contact with the complainant's address, which is on Larkia, Larkia Lane. So don't be on that street, you understand?
Yes, ma'am.
Proof of employment within 30 days. There's to be no employment as a home healthcare provider or with minors. Field visits 1 time per month until further notice. 100 hours of community service restitution. TAP evaluation, that can be out of custody. Follow recommendations. And they're asking for a MIC evaluation. I'll go ahead and do one. MIC evaluation out of custody. And I'm going to order anger management classes and a life skills course. The court will give him 50 hours credit for completion of the anger management class towards his community service restitution, and another 50 hours credit once the life skills course is completed. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did
Yes,
you
ma'am.
understand it? And
ma'am.
did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, in order to be successful at probation, communication is key. If you have an issue with probation, let the probation officer know. If there's anything you need help with, let them know. If you feel they're not addressing it, you can always come back to the court. Do you understand?
Yes, ma'am.
All right, good luck to you. Who's the attorney on Raleigh?
Yes, Your Honor. Sorry.
He was talking to the phone.
All right.
I'm spinning. a lot
Oh,
of
are you
plates.
all ready or no?
Your Honor, we need 2 weeks to allow Mr. Riley to get his affairs together and we have an offer. We haven't rejected it. I got appointed from the bench.
Yes.
And there's an offer in there and we're discussing it and we're close to maybe coming to a resolution. He needs to make sure he can get square with some family members before he takes the deal.
All right, on this case, set it for a contested in 2 weeks. I'm sorry, it's not for a contested. This is just a regular case.
Yeah,
Do a plea deadline date and you say May 29th.
yes.
All right, May 29th. Once you sign the reset form, you're excused.
Okay, yes, ma'am.
All right, thank you.
Thank you, Your Honor.
You're welcome.
Yeah, I'm spinning a lot of plates today, which is good.
Judge, I did look, I actually did the plea and it was, the language was changed. And it does say less than a gram.
All right,
It's
so
written
then
in.
what
It-
we'll do is, I'll send an email to Barbara. She'll, y'all can change the judgment. On this, the judgment should reflect that it's a state jail felony. All right,
Hey, Coach Judge.
yes.
So I've gone through everything with Marco Moreno Vasquez. He has no further questions. Just want to let the court know.
All righty, Mr. If you can come down, please. If they can give me his file, please. And I'm sorry, what's your client's name again?
Marco Moreno Vasquez.
Can I see the file on Marco Moreno Vasquez, please? All right, so you had a chance to see everything?
Yes.
All right, so we'll bring you back for your jury trial on December 9th. As I said, if there's an opening that's sooner, the state will reach out to your defense counsel and we'll bring you back. Any other questions?
No, it's all.
No, that's it.
All right, thank you. Thanks,
you, Judge.
counsel.
Thank you.
You're welcome.
Maybe it's good, yeah.
Yes.
Sorry.
Who's here on Adis Hernandez Rivas? Okay, we'll wait for them.
And it's Monica Guerrero.
So, well, on this case,
So yeah, it's gonna get,
reset.
needs to be reset till at least after, so the week after, maybe December 9th. Probably be the 16th or the 15th.
Norma, on this case, move it to December 16th. It's on Adis Hernandez Rivas. Yes. All right, and Robert Porter on Bowen, just let me know whenever you're ready. All right, thank you. Are the parties ready on Freddie Ariano? Court is calling 2024 CR 010818 and 2024 CR 010820, State versus Freddie Ariano. Can I have parties announced?
Ashley Jones for the state.
Melissa Christian for the defendant.
And are you the defendant in this case?
Yes, ma'am.
Counsel, in each of the cause number, have you received all discovery? Did you review it with your client?
I have, yes.
Court will find that the state is in compliance with discovery. And each of the cause numbers, did you review the true bill of indictment, sir, with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment in each cause number?
I do, Judge.
State, are you proceeding on the indictment as presented and the cause number ending in 18?
We are not, Your Honor. The state is proceeding only on count 2 of that indictment, and we will waive the remaining counts.
No objections.
And are you proceeding on the indictment as presented and the cause number ending in 20?
We are not, Your Honor. The state, again, will proceed only on count 2, but paragraph D of that indictment.
No objections.
All right, and each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And the cause number ending in 1-8, you're charged with aggravated kidnapping, bodily injury, and cause number ending in 2-0, you're charged with aggravated sexual assault. Each of those cause numbers, the range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has.
In each of the cause numbers, do you believe your client has a rational as well as a factual understanding of the charges against him?
I do so believe, Judge.
In each cause number, do you believe your client is currently competent and was legally sane at the time of the offense?
Yes, Your Honor, and just for the record, he was assessed psychologically and came back competent.
And sir, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement
Yes, Your Honor.
with your attorney and did you understand it?
Yes, Your Honor.
In each cause number, the state is proceeding on count 2. And in the cause number ending in 2-0, they're proceeding on paragraph D of count 2. Punishment is to be assessed at 10 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon. There are no applications. The case will run concurrently. There's an affirmative finding of family violence. There's to be Chapter 62 compliance and no contact with the complainant. Did you understand that to be the plea in each of the cause numbers?
Yes, Your Honor.
Defense, is that the plea?
That is, Judge.
State, is that the plea?
Yes, Your Honor.
In each of the cause numbers, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge, motions have been filed, but the answer to your question is no.
And cause number 2024 CR 010818, how do you plead to count 2?
No contest.
And cause number 2024 CR 010820, how do you plead to count 2, paragraph D?
No contest.
State any evidence in each of those cause numbers.
State offers State's Exhibit 1 and all attachments for both cause numbers.
We have no objection in either cause.
In each cause numbers, did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. In each of the cause numbers, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
We are, Judge.
All right, state, is there a reason the court should follow this agreement?
Yes, Your Honor. We have spoken with the complainant in depth. She is an adult and this is the outcome that she wants.
All right, then cause number 2024 CR 010818, the court is finding you guilty. There's an affirmative finding. There is to be a $1,500 fine. This will run concurrent with 2024 CR 10820. There's an affirmative finding of family violence. There's to be no contact with the complainant. There's to be no contact with minors. And there's 10 years in the prison. Credit for any time served. Is there anything else with regards to sentencing in that cause number?
Your Honor, was this clause number 20?
No, this is 10818. In that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Next, the court is proceeding with 10820. The court is finding you guilty. There's an affirmative finding. And also an affirmative finding of family violence, Chapter 62 compliance. There's a $1,500 fine, 10 years in the prison. This will run concurrent with 2024 CR 10818. There's to be no contact with the complainant. And there's to be no contact with minors. Is there anything else with regards to sentencing in that cause number?
Not from the state, Your Honor.
Nothing from the defense.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal in that cause number? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You're receiving the 10 years because the complainant was satisfied with your receiving 10 years. If you would have went to a jury trial and the jury were to find you guilty, they probably would have given you life. You understand?
Mhm.
You're not supposed to treat people that you claim to love this way. You understand?
Yes, Your Honor.
All right, my understanding, there's going to be a victim impact. The
Yes.
deputy's going to take you over to that side. You court is calling 2021 CR 9092W State versus Christian Reyna. Can I have parties announced?
Megan Galloway for the state.
And are you Christian Reyna?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and First Amendment Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand that?
Yes, ma'am.
Are you the same Christian Escobar Reyna who was placed on deferred adjudication in cause number 2021 CR 9092W for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams?
I am, Your Honor.
All right, state.
Violation of condition number 4. In Bexar County, Texas, the defendant Christian Escobar Reyna did then and there fail to report to the supervision officer as directed for the months of September of 2024 and January and February of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
Violation of condition number 4 on or about the 4th day of March 2025 in Bexar County, Texas. The defendant Christian Escobar Reyna did then and there fail to report as directed by the court for a compliance hearing in the 187th District Court in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
And then violation of condition number 4 in Bexar County, Texas, the defendant Christian Escobar Reyna did then and there fail to report to the supervision officer as directed for the months of March of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
We waive and abandon the remainder, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violations 4, 4, and 4, the court can find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
I understand, Your Honor.
Knowing that, do you still wish to plead true to violations 4, 4, and 4?
Yes, ma'am.
Court will find 4, 4, and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking for revocation and that the defendant be sentenced to 2 years in the prison based on his lack of actively participating in his preferred education.
All right, and what are you requesting?
And Your Honor, I was also that for a plea of truth, it would be TIC a new number one.
And that's correct, Your Honor. We TIC, cause number 2025 PF 15283.
And what is that offense?
It's a possession less than a gram.
All right.
And for that reason, my client is asking for lifetime recovery, Your Honor, as an alternative to EC. He would like to address the court if the court will allow.
Sure. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Christian Reyna.
All right, so this is not your first motion to revoke. Your previous motion to revoke was for not reporting. And now we're back here for not reporting. And then the court tried to see what was going on with you. I set it for a compliance hearing and you still did not show. The only thing you've accomplished on this probation is picking up a new number one. What would you like to discuss?
First of all, I want to say that I have two kids.
No, don't bring your children into this because you had two children when you were placed on probation. You had children when you were not doing what you're supposed to be doing on probation. So do not use your children to play sympathy and say, oh, my children really need me. You were not a good parent to your children while you were using drugs. So you haven't been in their lives. Don't pretend like you've been seeing them. And if they're in school, that you've been keeping up with their schoolwork and going over homework with them and going to any plays or events or extracurricular activities they've had, because you have not been doing that. Now you want to come to me and you're using your children as a reason why I should continue you. So let's not start there. Let's start by taking responsibility for our own actions.
Yes, ma'am.
So what would you like to say?
I have everything going for me out there. I have a supporting family that loves me and wants me there. And I just have this problem that it's my drug use. And that's all really that's my only problem. I'm a good person. You know, I'm trying to do what I'm supposed to do.
All you had to do was pick up the phone and call probation. I tell everybody who has drug issues to reach out to your probation. If you think you're going to use, reach out to your sober support person. If you can't get in touch with anybody, you can still come back to court. And I tried to have you get back on track by setting it for a compliance hearing, and you still didn't show. So basically what you want to do, it appears to the court, you're not trying to be clean and sober because you're not reaching out to call anyone. You're acting as though you're not on probation. And there, I can't help you. I can't help you anymore because you don't want help.
I understand.
All right. Court is going to find you guilty. The court is going to revoke, take into consideration 2025 PF 15283. The state is requesting that your sentence be 2 years in the prison. I would sentence you to 4, but I'm going to go along with the state and sentence you to 2 years in the prison. I'll request the therapeutic community. And if you're truly serious about your condition, the therapeutic community will most likely accept you, but you'll have to request it.
Yes, ma'am.
And I'll give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
I did, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
We can go off the record. Here's the thing. I'm gonna reach out my hand to you again. When you're released from prison, if you can't find a place to stay to help you with your sobriety, if I'm still here, you can come back here. I will pick up the phone, get a placement for you. Do you understand?
I understand.
Only two things can happen with the path you're on. Either you're going to end up in prison or jail for a majority of your life, or either somebody's going to be identifying your body. You understand?
I do.
All right. Good luck to you. Okay.
Thank
You're welcome.
Thank you, Judge.
You're welcome. All right. What is happening on this case? Where are we on discovery?
Judge, we have received discovery. We're currently reviewing it.
Okay.
I also have conferred with our client, and he has some things he'd like for me to pass on to the state. So we're gathering that information for them as well.
All right. And state, on this case, was an offer able to be tendered?
Yes, sir.
Ms. Ferguson, if I can have a 30-day reset for a plea deadline date. All right, you're going to come back on June 12th. At that time, you need to let the court know whether or not you reached an agreement with the state. If you have not reached an agreement, your next court date is going to be a jury trial setting.
Sure.
All right, just have a seat and they will give you a reset form. Once you sign that, you're excused.
Thank you.
Thank you. Good seeing you. Berlinga. All right, on this case, were you all able to receive the discovery?
Yes, Your Honor, we have defense is satisfied, and I think both sides have turned over what we have.
All right, Ms. Ferguson, I need a jury trial date. So what is this, 3 days?
Probably this wrong.
Tops.
All right, 3-day jury trial date for family violence. I'm sorry, okay, June 3rd.
Yes, ma'am.
All right, once you sign the reset form, you're excused. Your jury trial will be June 3rd.
Thank you.
Thank you. And counsel, if you make sure, if you all have not done so, to do the acknowledgement of discovery.
Yes, ma'am.
All right, thank you.
I've signed several.
Okay. Fabian Rodriguez.
Judge, there's an unindicted felony pending. It's failure to stop and render aid. I spoke to Jason Garrahan and he's gonna get with grand jury, find out what's going on with that case. We anticipate the court will schedule this one for a contested hearing, perhaps as early as next week, if you'll do it. That way, we can be in front of you with all of the cases instead of just one.
State, are you in agreement to setting this in 10 days for a contested, or do you need more time?
Well, Judge, like I told Mr. Montgomery, we would be waiting probably the new number one to go in on technical. So, I mean, it is what it is because it won't resolve all of his cases, but it can be if that's what the defense would like.
I just feel like I need to explore that option to make sure that we don't leave anything.
All right, Ms. Ferguson, if you call this back in 10 days, then.
Also, Judge, it's a motion to enter adjudication of guilt and he's remanded without bond. If the court would set up a bond, I'd ask you to do that.
All right, if you all will file a motion and then I'll hear it. All right, so we're gonna come back on May 29th for a contested hearing.
Thank you, Your Honor.
All right, thank you. Who is here on Brandon Bauman? All right, court is calling 2023 CR 6541 State versus Brandon Bowman. Could I have parties announced for the record for the state?
I think gallery for the state.
And is there a motion to correct the motion to revoke?
Yes, Your Honor, ask the court to amend the motion to revoke to reflect that the defendant is on deferred for the state felony offense of possession of a controlled substance. UG1 less than a gram.
Any objection?
No objection.
All right, Mr. Bowman, did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Brandon Bowman who was placed on deferred adjudication in 2023 CR 6541 for the offense of possession of a controlled substance penalty 1 less than 1 gram on May 28, 2024 for a period of 4 years? Is that you? State?
Violation of condition number 1 on or about the 21st day of March 2025 in Bexar County, Texas. The defendant Brandon Bowman committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violation of condition number 1 on or about the 21st day of March 2025 in Bexar County, Texas. The defendant Brandon Bowman committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of conditions 1 and 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violations 1 and 1?
Yes, ma'am.
Court will find violation 1 and 1 true. Is there a proposed agreement?
There is, Your Honor, it is to adjudicate the defendant guilty, revoke his community supervision, sentence him to 8 months in the state jail facility, and for the court to take into consideration cause numbers 2025.
Just 1 second. 2025?
Yes, 2025 CC 004565 and 2025 DC 004679.
All right. Is that the agreement, counsel?
It is, Your Honor.
Are you asking the court to follow this agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement. The court will find you guilty or revoke, sentence you to 8 months in the state jail facility, give you credit for any time served, take in consideration 2025 CC 004565, 2025 CC 004679. Is there, and the court will order a therapeutic community. Is there anything else with regards to sentencing? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, ma'am.
You're gonna have to do better in your life because we're off the record. One or two things gonna end up happening. Either you're gonna end up in jail or in prison for all these drug charges that you keep picking up, or either somebody's gonna have to identify your body. Those are the only two choices. Once you're released from custody, if you can't find a place that can help you with your sobriety and help you get your life in order, if I'm still here, I'll pick up the phone and get you the help you need. You understand?
Yes, ma'am. Thank you.
All right, thank you. All right, court is calling 2023 CR 9998 State versus Felix Acuna. Could I have parties announced for the record for the state
Megan Galloway for the state.
defense?
Dwight Chumley for Mr. Coon.
All right. And are you Mr. Acuna?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision and State's Motion to Supplement Pending Motion to Revoke Probation? With your attorney, did you understand it?
Yes.
Are you the same Felix Xavier Montoya Acuna who was placed on community supervision in 2023 CR 9998 for the offense of driving while intoxicated with a child under 15 on March 28, 2024 for a term of 2 years? Is that you? All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Felix Xavier Montoya Acuna did then and there fail to report to the supervision officer as directed for the months of July, August, September, October, November, and December 2024 in violation of condition number 4.
How do you plead to that? True or not true?
Yes, ma'am. True.
State.
Violation of condition number 4 in Bexar County, Texas, the defendant Felix Xavier Montoya Acuna did then and there fail to report to the supervision officer as directed for the months of January, February, and March 2025 in violation of condition number 4.
How do you plead to that? True or not true?
We waive and abandon the remainders, Your Honor.
Any objections to the waivers?
No.
Did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, sentence you to 2 years in the prison and up to a $500 fine? Knowing that, do you still wish to plead true to 4 and 4?
Yes, ma'am.
Court will find violation of condition 4 and 4 true. Is there a proposed agreement?
There is not, Your Honor. The state is asking that you revoke the defendant's community supervision and sentence him to 2 years in the state jail facility based on the stipulations that he has absconded from probation and the court since going on 10 months.
Your Honor, we have a explanation due. If I might inquire of my client. Your Honor.
Yes, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Yes, Mr. Coon, you're here in front of the judge today, and you've been on probation for a little over a year, maybe a year and a half. Can you explain to the judge, you pled true that you did not report on the various months in 2024. Can you explain to the judge what your situation was and why that did not happen?
My situation was that I was traveling back and forth from San Marcos to San Antonio, and back and forth, I didn't have time to check in. I know I should have picked up the phone, honest to my heart. I know I should have called at least several times, but I didn't. Between work and back and forth traveling, finding transportation to get over there and come back was hard for me, and I.
So here's the thing, if he was actually living in San Marcos,
No.
I was gonna clarify for you.
Yes.
I was explaining to the judge, you were living in San Antonio and working in San Marcos, is that correct?
Yes.
And what type of work were you doing there?
I was doing construction. taping
I don't
up the-
understand.
I was doing.
Here's the thing, though.
plumbing.
I don't understand why you didn't pick up the phone to call probation. I thought his testimony was gonna be, I was in a coma. I just woke up. Or either I had a serious injury. Or either I was kidnapped by strangers and I just found release. What you're giving me is not a good excuse for not reporting. Because in this court, I always tell people if there's an issue, let your probation officer know. All you have to do is pick up the phone and call somebody. You're telling me you should have known, you should have called somebody and you didn't.
I got busy with work, yes, ma'am.
So I don't know what you want me to do.
Yes, I will, if I might ask, you were required to connect on a interlock device for your vehicle, is that correct?
On my vehicle, yes,
And you were able, you did go through the process of doing that, is that correct?
on the homing device.
Okay, and then you had another requirement, condition that you met involving the training report, which you explained to me that you had done. You have records of doing.
On the process of me being on probation, I had completed the education program, the DWI education program. And on the other side, I did complete the DWI in voluntary.
We have proof of that?
The VIP, the impact program, and I also have a certificate for the family parent class.
All right, where's the certificate?
I have it at home. I did not appreciate, I mean, I appreciated that I'm here at court, but I did not know, and I don't have any
Oh,
relatives
did you
here.
ever turn that over to probation that you've completed that?
I sent a message to my probation officer.
All right, probation, do you have proof that he has any of that? All right, is there anything else?
If it makes a difference to you, Judge, I could, if you give him a couple of days. He's been in custody, how long now? 60 days?
60 days. I am a trustee too, so yeah, 60 days.
I could maybe fetch that stuff for you.
All right, this is what I'm gonna do. I'm gonna revoke you. I'm gonna sentence you to 2 years in the state jail facility, give you credit for any time served. There's a 2-year license suspension. And I'll order the therapeutic community. Counsel, if you're able to provide the court proof that he has done those things, then the court will reconsider, not revoking him, but reconsider the amount of time.
Thank you.
All right,
Appreciate it.
you're welcome. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. All right, we can go off the record. So if your attorney is able to bring documentation to the court that you have actually done those classes, I will reconsider the sentence of 2 years. I'm not going to continue on probation. I don't think you're a good candidate for probation, but I'll consider classes that you've completed. Do you understand?
Okay, bye.
All right, thank you.
Yes.
Huh?
Yeah.
We'll bring you back.
Give me a
We're
phone
gonna
number.
bring you back.
Yeah. Who do I call? Okay.
Yes, we'll get them to you.
478
Okay.
81
478.
427. My bad, I'm sorry, 427 64 80.
All right, and Melissa,
Yes,
And
sir.
her name
on
is
your
Arlene.
case, if you all have already done all of the paperwork, you can appear by Zoom.
No.
All right. Alex Bacon, if you'll come forward.
Yeah.
Hello.
Hi.
Hi, your attorney is out ill. Have you had a chance to speak to him?
No, ma'am, I called, I got no answer. I left a voicemail, no call return, and.
All right, if you would like another attorney appointed to you, we can appoint another attorney. Otherwise, we'll
Yes,
reschedule.
ma'am, because it's not the first time.
All right,
It's the
so
second
here's the thing. I'm just asking what would you like, okay? I don't know, I don't let people speak negatively about other people when they're not present, okay?
I'm not speaking negative, I'm just.
Well, no. What I'm telling you is he's out ill.
Oh, okay.
So that's why he's not here. It's not because he doesn't return phone calls. It's just that he's out ill. So I can reset this in 2 weeks, have him here, or I can have another attorney appointed for you.
I prefer another one.
All right. So if you have a seat, we'll get that for you, okay?
Thank you.
Thank you. All right, Fernando Jimenez. All right, the court is calling 2025 CR 0011924 and 2025 CR 000637. State versus Fernando Jimenez. Can I have parties announce?
Rick Pena for the state of Texas.
Melissa Christian for the defendant.
And are you Mr. Jimenez?
Yes, ma'am, I am.
All right, defense, do you have any objection to defense counsel appearing by Zoom?
We have no objection.
I'm sorry, state, do you have any objection? All right, Melissa, you were about to object to yourself. You're like, why is the judge asking me that? All right, Mr. Jimenez, do you have any objection to your counsel appearing by Zoom?
No, ma'am.
All right. Attorney Christian, did you receive all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
There are not.
All right, Mr. Jimenez, did you review the documents
Yes, ma'am, I did.
entitled True Bill of Indictment with your attorney? Did you understand them?
Yes, ma'am.
Counsel, do you waive the reading of the indictment in each cause number?
We do.
State in cause number 2025 CR 001924, you're proceeding on the indictment as presented?
No, Your Honor, they will be proceeding on that case with regard to only count one, we'll waive count two, and then we'll waive the repeat offender enhancement.
No objections.
And then in cause number 2025 CR 000637, are you proceeding on the indictment as presented?
Your Honor, we will waive the repeat offender enhancement with that case as well.
No objection.
All right, Mr. Jimenez, did you review the documents entitled Court Admonishments with your attorney? Did you understand it? And
Yes,
did you sign it in all the appropriate places?
yes, ma'am, I did.
You're charged with evading arrest, detention with a vehicle and assault family household member with a previous conviction. Those are each third-degree felonies. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I do.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering into these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, I did.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Jimenez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am, I am.
Are you a U.S. citizen?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, I do, and I did.
All right, according to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. In one cause number, there's a $1,500 fine. There are no applications in either cause number. The cause numbers are to run concurrently. The state will take in consideration 2025 CC 002355. And the cause number ending in 37, there's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand that to be your plea bargain agreement in each cause number?
Yes, ma'am.
Defense, is that the plea?
That is.
State?
It is the plea, Your Honor.
Did you review the waiver of appeal paragraph in each of the cause numbers with your attorney? Did you understand it and sign it in both places?
I did not, yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
Motions have been filed, but none heard, Judge.
And cause number 2025 CR 001924, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right. And just so the record can be clear, in cause number 2025 CR 000637, did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
And did you understand that also with an affirmative finding of family violence, you cannot be designated as primary custodial parent?
Okay.
No, not okay. Do you understand that?
Yes, ma'am.
All right. Knowing those things, do you still wish to proceed with this plea?
Yes.
All right. Then in cause number 2025 CR 000637, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, and each cause number, is there any evidence to support the defendant's pleas?
Yes, Your Honor. With regard to both cases, they will offer each evidence as exhibits 1 for 2025 CR 001924. And with regard to 2025 CR 00627, in terms of one contest.
No objection in either cause number.
All right, and state in the cause number with the complainant that he is to have no contact with you. I mean, with her, have you had any contact with the complainant?
Yeah.
All right, thank you. You may be excused. In each cause numbers, did you review the document entitled waiver and consent to stipulations of testimony and stipulation with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. In regards to cause number, we're back on the record. In 2025 CR 001924, the court is going to find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
All right, and that cause number, the court will sentence you to 6 years in the prison, give you credit for any time served. This is run concurrent with 2025 CR 000637. In that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because that's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. And let me give you a copy of your trial court certifications.
Thank you, Judge. Thank you.
You're welcome. We're off the record while they're getting that. Here's the thing. This whole, what I've read in the police report, if you think somebody's paying attention too much to somebody that you care for, guess what? Be happy that somebody thinks the person that you're with is attractive, intelligent. But there's no cause for any of this. Now, what's going to happen is you're going to prison. You know? And if you think somebody is being unfaithful to you or cheating on you, then you only really have 2 choices in life. Either you accept it and forgive them, or either you say, I didn't sign up for this. This relationship is over, and keep it moving. But you don't do this, because otherwise you end up where you are now, which is going to prison.
I understand, Your Honor. I know I'm in a toxic relationship, right? I did try to file for divorce with her. She doesn't want to file, she doesn't want to sign the papers.
Oh, then you just keep it moving. And you can write a Lifetime movie about how you're such a great guy, so attractive, so intelligent, that this woman cannot leave you alone. But what you did in this, You can't do that. You gotta let it go. You know? And move on. And if somebody won't give you a divorce, I will tell you. You can get a divorce from somebody if you really want a divorce, whether they show up or not. I've had people before, they said, I'm not gonna agree to service. I'm not gonna let you serve me. Guess what? Texas has something where you can actually just serve it by placing it in a newspaper, and they'll put it on a board at the courthouse. And that's your constructive service. So this whole thing where I'm never gonna give you a divorce, catch me if you can and get somebody to serve me divorce papers. It's really a bunch of nonsense because you can get a divorce without having to physically serve somebody.
It's not like not giving the divorce, it's like, I don't know how to go about it, you know? Either it's a financial problem or whatever it means, I
Oh,
don't
you
know.
can go to the Bexar County Courthouse. They actually have somebody over there who will help you. Now, if you're fighting for major property and everything, that's something different.
And well, she has I have a daughter with her and she holds, I pay.
Let me ask you something. And this is just information for me and what I always tell my clients. What I would tell my clients, that person who you say is toxic, who is now acting crazy. Yeah, once in a while, somebody will appear like this great person. You've dated them for 2 years. They've been great. Time when you sign paperwork, they turn in this other person and they're crazy. But usually you have some red flags that there is some crazy in that person, but you just choose to ignore it. We're back on the record. Any objection, Ms. Christian, to the amendment of the state's waivers?
There is no objection.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence in cause number 2025 CR 000637 to find you guilty. The court will find you guilty. Court will sentence you to 6 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. This will run concurrent with 2025 CR 001924, taking consideration 2025 CC 002355. There's an affirmative finding of family violence. There's to be no contact with the complainant and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes,
And did you sign it?
yes,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
yes, ma'am.
All right, we can go off the record, make better decisions. All right? If you have an anger issue, you better take care of it. Because ask yourself, do you want somebody to treat your daughter the way you treat others? I think the answer to that is no. You know what somebody once said? They said a daughter's first boyfriend is her father, because from that person, they learn how they're supposed to be treated in relationships. All right? Good luck to you.
Thank you.
May I be excused, Judge?
Yes, you may. Thanks. Have a good
Thank
one.
you. You too.
Willard Cummings. If anybody else is ready, please just let the clerks know so they can put your file up here. All righty. So we are here for a bond.
Yes, Judge, we have a motion to set bond.
All right, let me just pull up his case very quickly.
Oh, sorry, Judge.
Oh, no problem. Thank you. All right. So he has a motion to revoke?
He does, Judge.
All right, does anybody know what the allegations in the motion to revoke is? All right, thank you. All right, court is calling 2024 CR 009473 State versus Millard Cummings. Can I have parties announced for the record?
Raymond Martinez for Mr. Cummings.
Are you Mr. Cummings?
Yes, ma'am.
All right, you're on deferred adjudication for assault family household member. All right, this motion to revoke, let's go off the record. All right, the motion to revoke is not correct because it shows that he's on bond for a misdemeanor.
It was reduced.
All right, so y'all maybe want to change the motion to revoke, the wording of it. I mean, we'll let them know. So is he on, do we know, let me pull it up. Because I need to see if he's on for assault. Just a regular assault, or did y'all make it an attempt? Let me see what it is. All right, let's do this. Before he is, yeah, it's just assault, bodily injury family member. So let's do this. Let's have them correct the motion to revoke, because otherwise he'll be released and then he'll get rearrested. So if y'all just give us a moment to have them put the correct motion in the system, and then I'll hear your request for a bond.
Yes, Your Honor.
Yes.
Would it be best to withdraw and refile, or could the state request an oral amendment?
Defense, will you object to an oral amendment?
We wouldn't, Judge.
All right, so just do an oral amendment, but we're not gonna hear the motion today, though. All right. All right, Mr. Cummins, you can come back down. All right, so we're back on the record in 2024 CR 009473. So there's a motion to enter adjudication of guilt and revoke community supervision that has been filed. With regards to the motion to enter adjudication of guilt and revoke community supervision, are there any amendments?
Yes, Your Honor, this I would like to order Tennessee amend that motion from what it reads as assault family, strangulation family to assault family household. By same student.
Any objection?
No, Your Honor.
All right, then next we are here to hear a request for a motion to set bond. And the defendant is entitled to a bond because he's on deferred adjudication. So have you all agreed to an amount or no?
We haven't even talked about the amount, Judge. Sorry. I can, give me 2 seconds.
Sure.
We are not in agreement, Judge.
All right, so defense, it's your motion.
Judge, we just asked the court to take judicial notice of his prior bond amount and take into consideration what we now know to be the case he's actually on probation for, and set an amount that the court feels is appropriate.
All right, and state, what amount are you requesting?
The state would ask for an amount not less than $20,000, given the fact that the defendant was just placed on probation barely 3 months ago. That he essentially tried to do things his own way. He didn't do the state approved BIP course. He tried to do a different course that was unapproved. He failed to submit to drug test. Was failing to submit to the UA hotline. That's just one I'm talking about. I'll pull up the exact. I know that there was, he tried to buy a gun as well, Your Honor, which violates the affirmative finding of family violence that was issued in his original charge. Given all those activities in a short amount of time since he applied, state would ask no less than $20,000.
All right, this is what the court is going to do. The court is going to set your bond, and the reason why the court is setting a bond in this case is because legally I have to set a bond for you. The court will set your bond at $20,000. There's to be full GPS, and the court will ask that the fees be waived. Is there anything else?
No, Judge, but.
All right, Ms. Ferguson,
Yes, ma'am.
we need a date. Is this going to be a contested?
I don't believe so, Judge, but I'm going to stick around after we're done and confer with the state about potential resolutions.
All right, Ms. Ferguson, then set this in exactly 10 days for a contested hearing.
The May 29th.
All right, we're going to come back on May 29th. All right, who is here on Paul Garay? And after Garay, it will be O'Banion, And then it will be Morales. Probation, there are no applications in this case. Court is calling 2025 CR 0033460 State versus Paul Garay. Bad parties announced for the record.
Todd Coronado for Mr. Gray.
This is a lot of paperwork for a possession less than a gram. All right, and are you Mr. Garay?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garay, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Garay, did you review court admonishments with your attorney? Did you understand it?
Yes, I do.
And did you sign it in all the appropriate places?
Yes.
Did you understand your charge of possession of a controlled substance penalty group 1 less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
I do.
If you have a plea bargain agreement with the state, the court does not have to follow that agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
Do you believe he's currently competent and was legally sane at the time of the offense?
That's correct, Your Honor.
Mr. Garay, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
I know that.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 103 days in the Bexar County Jail under 1244, and there's an $800 fine. Did you understand that for you to plea?
I did.
Defense, is that the plea?
That is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states 1 in attachments.
No objections, Your Honor.
All right, state, you may be excused. Did you review the documents and title waiver and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the following. The court will find that there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, he just basically was in the wrong place at the wrong time that evening, and he wants to put this incident behind him, get on with his life, because he's soon or turning 50 next year, so he wants to put this behind him and move on with his life. Is that correct, Paul?
Yes, ma'am.
All right, the court is going to find you guilty. The court will sentence you to 103 days in the Bexar County Jail under 1244. Give you credit for any time served. There's an $800 fine. Time and money will run concurrent. There's to be no contact with the following people: Joseph Lee Angelus, Gregory Lee Green, Jennifer Lee Flores. Let's see. And there should be no contact with 12350 IH10 West, San Antonio, Texas 78230. Did you review the documents entitled Trial Court Certification of Defendant's Right to Appeal with your attorney? Did you understand it? And did you sign it?
I did.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do.
All right, we can go off the record. Here's the thing. When you're released from the Bexar County Jail, if you need help with your drug problem or to maintain your sobriety, if I am here, you can always come back here and I will pick up the phone and call for a place to help you. Because otherwise, only two things are going to end up happening to you, right? Either you're going to end up back and forth out of jail, back and forth out of prison, and your time is going to start running by very quickly because you're almost 50. So I'm in the same boat as you are, because if I have more of my life behind me than in front of me, unless I'm planning on living to be 200 or something. I hope it happens and I hope I'm in good shape. But if not, it's not going to happen. So if you don't end up in and out of prison, somebody's going to end up identifying your body, and you don't want that to happen, okay? All right, good luck to you, all right?
Thank you. It's what the Officer Weiss said, the same thing. He said, you're a good guy and you're out there. One of these times it's gonna hit you in the butt, and it did because of being around the facilities.
Oh, yeah. And then you have a lot of things going on. You're homeless, you're living on the street.
Yeah.
You're using needles. You don't know if there's some kind of germ on the needle. And when people are giving you drugs and you're getting drugs, there's no FDA requirement. People are just mixing things. And if you were to die, you know what they say? That's okay. We have another customer. They don't care, right? All right, good luck to you, okay?
Thank you.
You're welcome.
I'm gonna be excused.
Yes.
Thank you.
All right, you ready on bacon? Sure.
Yes, Your Honor.
I was gonna do Miss O'Banion first, but okay.
Mr. Bacon and I are gonna request some opportunity for me to get the discovery.
All right, Mr. Bacon, come forward.
We've traded emails, and I'm gonna get in touch with him as soon as I get a hold of the discovery.
Not cell phone numbers, though.
Yeah,
All right. Ms. Ferguson, I need a 30-day reset.
thank you.
All right, so we'll come back on June 12th. This will be your attorney. And once you sign the reset form, you're excused. State on bacon on June 12th, you need to be prepared to tender an offer.
Yes,
All right, thank you. All right, Ms. Abrams, on this one, they said that they had done a MIC evaluation. Thank you. We're going on the record in 2025 CR 0000451, State versus Leslie O'Banion. Could I have parties announced?
That's Dwight Shumley for Miss O'Banion.
Yes. All right, you entered a plea of no contest on May 12th of 2025. According to your plea bargain agreement,
May I give you this, ma'am? Ms. Susan Boyd?
to what point, why are you giving me that?
It's my waiver.
It's your
for
what?
you, ma'am. It's for you, Judge. Thank you.
No, what is it for? That's what I'm trying to.
Motions That I did.
All right, so here's the thing, you've entered a plea, unless that's a motion to withdraw your plea, that is, it's not appropriate at this time, okay? All right.
It's kind of is. But
Well, I mean,
I would
are you
just like to, I did the work
It's
on it.
Your Honor, it's a
It's
writ of
okay.
habeas, it's a writ of habeas corpus.
It's a written motion to reduce state jail felony to misdemeanor.
All right, so the state jail felony is
And
not
writ
being,
of habeas corpus.
all right, the state jail felony is not being reduced to a misdemeanor. All right,
Okay. Well, Okay.
No, 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 I
You know,
appreciate
because
it.
he's
No,
not
no.
really doing a job.
No, no, no. He's actually doing an excellent job for you.
I don't agree, but okay.
Well, I mean.
That's what I got, so that's what I gotta deal with, so I signed up
Well,
probation.
no, no, no. Here's the thing, what I'm telling you, and this is what I want
Just
you to
would
hear
like to
me.
go home
I want you to hear,
on probation, and that's what I signed for Monday, right, Ms. Boyd, Ms. Leslie O'Banion? I signed for 3 years deferred.
Mhm.
So. I did my Kappa Val inside, so I'd like to be released to have probation, ma'am, thank you. That's what I find.
all right, so let me just tell you right now, that's not what you signed up for. What you signed up for is there was a plea bargain that was entered into. And guess what happens with plea bargain agreements? I'm the person who sets conditions, and I'm sure your attorney told you that. So whether or not you're released today, it's really up to me. So that's where we are.
Yes, ma'am, thank you.
I don't know why people continue to think that everybody
I don't know
can.
why I thought
Here's the thing.
probation's outside the jail, and
All
it
right,
is.
so then what I'll do, if you're gonna continue,
No, ma'am.
if you want to continue to talk over me, then you can do so.
No, ma'am,
But you're
I
gonna
don't
be
wanna.
talking,
So I'm
but
sorry. please
you
forgive
are
me, ma'am.
going to be talking over me and talking by yourself. And what I will do is I'll just set this for another day. So
I'll quiet.
what I'm telling you
Either
is I do
apologize.
not understand why everybody thinks that they can be an attorney without a license. If everybody could be an attorney, then guess what? We would not have gone to school for it. So,
God bless you, ma'am.
Mr.
Thank you.
Chumley,
Mhm.
thank you for your patience.
Thank you, sir, and thank you, ma'am.
All right, so this is
Ms.
what,
Judge Stephanie Boyd, please forgive me, and I'm sorry, I'm just very, miss my family very much. So I've been in for 410 days and I would like to see my family. It's my birthday this month. And I miss my family tremendously.
well, here's the thing.
So I
If you
love my
could, if
family
you
and they love
continue,
me.
if you continue to commit offenses, then that's not showing love for your family. Because the reason why you're not with your family now is because you've
I've
committed an
been away
offense.
from my family and I've
And actually, the offense
suffered very much
the
inside
offense,
Air County Jail, ma'am.
the offense that you have committed is
Okay,
an
cool.
injury to the elderly or disabled
Wow.
person, bodily injury. And that person is an elderly person. So that's why you are here. And what I can tell you is, if
Okay.
I follow this agreement, you are not going back to that location. You're not going to be allowed to be around any of those persons. Do you understand? Maybe she understands, maybe she doesn't. All right, so defense, this is my concern.
Okay.
My concern, have you all both read the MIC evaluation?
I have PTSD.
This is my concern in here. In my concern, she says she doesn't have any mental illness diagnosis, demanded that those be taken off the records, and that she will not be taking medications once she's released.
I have PTSD trauma. I do have that, ma'am. I do not have bipolar. So that seems to be a problem. It's outdated information from when I was 28 years old. I'm 48. I'm gonna be 49 this year. So that's very old medical stuff that's out of date, ma'am.
All
So
right.
I'm sorry for that, but that is actually true. I have PTSD, I have anxiety, I have trauma. That's what I do, diagnose it.
All right, probation.
Thank you.
How are we going to handle this? She's saying that once she's released, she's no longer going to take her medications.
I
Is
actually
there
am.
any?
So I have insurance. I'm gonna see my doctor. That's what I told the lady on the Taco Bell, ma'am. So I'd like to finish that, and I'm sorry she didn't put that in there. There's miscommunication happening, and it's really important to me, ma'am. I have insurance and I take very good care of my health. I actually have therapy set up for me already for when I'm released. I did that inside jail for the Rape Crisis Center. That's free therapy for me that I need. And I'm also going to go see my doctor and get on medication when I'm released. I take regular meds for myself and I take very good care of my health. I have health insurance. I'm on disability. So I plan on following up with my doctor I see currently in the Quarry Market. I have a doctor already. I have a pharmacy at Walgreens. So that is not actually true. I'm saying I have to follow up with my doctors on the outside where I take care of my health. And
All right, so
my mental health
probation,
is important to me.
how are we going to address this issue? How do you suggest we
So
address?
I'm gonna be taking meds. I will be complying with that. So that is not true, ma'am, and I'm sorry she wrote that. So I
Alright.
wanted to clarify. Please forgive me,
Thank
but
you
that
for-
is important.
Thank you for your clarification.
Yeah.
Probation, how are we gonna handle this?
I will be taking my meds. So
Judge,
I need to get them adjusted. Thank you. With the proper
Judge.
physician. Mine.
we can
I take meds
get
inside
it.
their county.
We can get an authorization to obtain records to ensure that she is actually
Walgreens,
going
Lincoln
to.
Heights.
All right, just one second. So let me ask you something. Ms. O'Banion,
Yes.
it appears as though maybe you're not medically
They have
compliant
out of
with your
date.
medications. The reason why I say that is because you're not able to control yourself at all. You're speaking over everyone who is talking. I've asked probation a question. You keep interrupting her.
It's,
So
I'm not.
what,
gonna
let me do this. What do you want to say to me? I'm here to listen.
Ma'am, what's happened since I've been incarcerated is they have out of date information. So me trying to update somebody that has old information, like I said, on me when I was 28 years old is so out of date. It is. I'm 48 years old, ma'am. So I've changed my life. I went to prison in Plain State 10 years ago and I changed my life, and that does matter. Okay? So I live a very good and healthy life for myself. I take care of myself and I support my own self. I'm a single woman. I live alone. I have a pet. And that's what I do. I support myself. I don't rely on a man. I take care of myself. And I've lived that way for a long time. I'm very strong, independent woman. That's the way my mom raised me. So I'm blessed to have that. You know, I pay my bills. And I always have a pet because I have trauma. I've groomed animals, I'm retired. And so I always have a fur baby, you know. I gave up my son for adoption. And, you know, this was something. I forgave my stepdad. I didn't report it. And I felt sorry for him. He's an older man. So it's my fault for that. There is issues there. He is crazy and he has broken my bones in the past, ma'am. I just didn't feel right about doing something against my family. So it's okay if they say I did something to him, and that's fine. So I apologize, but this is what really matters to me is I love my family and I miss my family very much. My brother has my car waiting for me.
They do not want to have any contact with you according to the police report. So
That's fine.
I'm not gonna allow you to
but
have
I've
contact
talked to
with
my brother inside jail,
all right.
and that's my brother. I have other family members, man, and he's married.
Okay.
So that's not my mama.
Okay.
And that I can still talk to my mother. That's my mom. She's married to my stepdad. I'm gonna not talk to my stepdad. That's the person, Danny. Okay, so that's one individual. So I'd like to clarify that. I'm not gonna already get in trouble when I'm not even released out, when I have families. There is toxic issues there, so that is a problem with that man. He has issues. So I will not be seeing my stepdad, period. I can see my mom on my own. She can come to my apartment. And that kind of thing, same with my brother. But, and his wife and kids, the same applies. I'm not gonna be seeing my stepdad though. I've already decided that myself personally. So I'm a strong woman, you know, but I would love my other family. I'm not gonna not see them. They love me.
All right, is there anything else you want to say?
And please forgive me, ma'am. I do take care of my health and I'm sorry that I've tried very hard because it's important to me to update people that had information on me. And it is important because that's about my health. And that's when somebody has old information that's not current, it needs to be updated, just like medical files, you know?
All right, is there anything else you want to say?
And please forgive me, ma'am. I am a very respectful person.
Is there anything else you want to say?
I'm sorry for talking, ma'am, but
Oh, no, you can
This-
talk. I'm giving you time to talk right now. Is there anything else you want to say?
you can call me crazy and say that, but I
Oh,
do
no,
love
I'm
my
not gonna
family.
call- I will
I'm a
not-
very strong
I
woman.
will not call you crazy. Is there anything else you want to
can.
say?
That's fine. I'm used
Well,
to
I
people
will
calling
tell
me
you
that.
this. I refuse to call you that.
Thank you. I don't like the stigma.
All right, so is there anything else? that you
No,
want to say to me?
no, ma'am. And I think you're a very awesome judge. You're doing a great job. And you are. And thank you for helping me.
All right, probation.
Thank you.
You're welcome. Probation,
Yes, Judge.
how are we gonna handle the fact that in the MIC evaluation, they're saying that she's not gonna take her medications? What do you
So
suggest?
I am.
All right, so here's the thing. I'm giving you time to speak.
Yes.
I did not interrupt you. I let you talk for as long as you want to talk. So now it's someone else's turn to talk. So do not interrupt them. And I want you to hear me clearly and internalize what I'm saying. If you interrupt them, what's going to end up happening is I'm going to send you back to jail. We are not going to hear this and I will bring you back on Monday. Do you understand? All right, probation. How do you suggest we handle this?
Judge, I think we should probably get an authorization of release so that we can be in contact with the individuals that are taking or prescribing medication, her doctors.
Mhm.
We can do a referral for Center for Healthcare Services. I believe the MIC evaluation indicates that she is not eligible for DDRF.
Yes.
However, she is eligible for the MIC caseload, I believe. And we could put her on the MIC caseload.
Okay. Is there anything else you think she would need?
Would you like to send me to DRF instead?
Did not tell you, no more interrupting.
Go ahead.
Yes.
Never let me out. Send me to DRF. Go ahead. I pray every day.
Judge, I really can't think of anything else other than maybe, a life skills course or moral recognition therapy or something like that.
Okay. All right, this is what the court is gonna do. Court is gonna sentence you to 3 years deferred adjudication. I'm sorry. 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, $1,500 fine, time and money to run concurrent. I'm sorry, that will be probated. Take in consideration 2025 CC 0000947. There's an affirmative finding of family violence. There's to be no contact with Danny Cox, Timothy O'Bannon. There's to be no contact with 14450 Old Frio City Road in Lytle, Texas, 78052.
Can't ask.
There's to be, she's gonna be placed on the MIC caseload. Referral to Center for Health Care Services. The defendant is to sign a release for mental health information. There's to be anger management course. TAP evaluation. That can be done out of custody, follow recommendations. Field visits 1 time per month until further notice. And there's to be no contact with minors.
Oh, gosh.
Probation, is there anything else?
Oh, I hate children.
I'm sorry, what?
Fuck you.
Like any type of employment or SSI.
Yes. Proof of employment
Behind the military.
or SSI within 30 days of release, no employment as a home health care provider or with minors.
I hate to ask you to do this, Judge, but can you give me that address again?
Yes.
She live in Bear County. You live in Bear
I'm
County.
gonna probably be relocating, I think.
Well,
So I
be right-
reside here now,
Okay.
but I will be relocating and moving my.
You do live in
information
Bear County.
No,
Where do you live?
yeah, I live nowhere right now.
All right, so
I haven't decided, I'm gonna be leaving. so I'll relocate.
You're to remain in Bear County until the court approves you to leave Bear County.
Cool.
If
I'll
you
be
leave-
hiring a realtor.
If you leave Bear County, what will end up happening is a warrant will be issued for your arrest.
I can relocate with somebody.
All right.
To another.
Uh,
city.
probation, is there anything
Okay.
else? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, counsel, did you review the trial court certification with her?
Yes,
And did you explain it to her?
yes,
And did she place her signature on the document?
yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. All right, thank you. State, make sure that you make the complainant aware of what has happened here today and that
Can I have a
there's a
copy of
no
my
contact
probation
order.
paperwork?
Okay,
Can I have a copy of probation paperwork?
you understand? All right, thank you.
My lawyer said it costs money. Oh, that's hard.
All right, Miss Abrams. She's to remain in custody until the TAP evaluation. Counsel, if you can approach, please. And do a TAP evaluation and a referral to felony drug court. All right, so based upon what your client said as she was going through the door, I honestly don't think it would be safe for the community or for her to be released from jail now. So we're gonna do a TAP evaluation while she's in custody.
Okay.
Do a referral to felony drug court. And
Yeah.
felony drug court can potentially address any mental health issues.
I think that's wise.
And also, if you want, we can also do a referral to the mental health court, which is across
Yeah.
the way. And state, if you have no objections, if they decide to accept her, because they'll only accept them if they're not on probation.
Right.
If they decide to accept her and you're in agreement with it, we can do a motion for a new trial and I'll grant it so that she can be there.
And I would like to say, Your Honor, I did have her psychologically evaluated. She was found competent.
Mhm.
And then these things are fluid, and I understand that, but she's never not understood what's going on. She has ideas of what she wants to see happen, but
Mhm.
I think she needs help, obviously. She needs mental health. So,
And there's already a trespass order, a no trespass order in place with her family. I don't know if she understands that or
Right.
not, but.
thank you, Judge. Appreciate
My
you.
concern while we're here is that if we move her across to the mental health court, my understanding that that's out of custody instead of in custody.
Well, not necessarily. They'll see what is appropriate for her. So if they decide that there's some sort of mental health treatment that she needs to do inpatient, they'll do that.
That's what I prefer. I just wanted her to be like mentally clear to rejoin the community, I guess you could say, because I don't think she's safe enough to rejoin the community.
Yes.
Thank you, Judge. And be excused?
Yes,
All right,
thank
appreciate
you. Oh, and probation, once the evaluation for felony drug court and TAP evaluation is done, she's not to be released, just have her brought back here.
Okay.
All right, thank you.
Cheers.
All right, Adrian Morales. I was wondering where you are. You just pop up like bam. Then you're here.
I slink around, Judge. There's a lot of training doing that.
I was just gonna say, where is he? I know he was supposed to be here. All right, so where are we on discovery?
I think I have all the discovery that's in the state's possession at this point, Your Honor. I don't have any complaints on that front. There are other matters to address with the court, but it's in terms of discovery, that's
All right, what matters need to be addressed with the court?
Mr. Morales, as I'm sure the court is aware, has recently been arrested for another driving while intoxicated offense. This happened at the end of this past month on the 29th of April. He was given a bond in that particular case. However, I know that he's been granted without bond due to the bond violation by the court. Of course, we understand. And So I would respectfully request the court would consider giving him a bond. I think the state would be in agreement with that request. However, we know it's fully within your discretion, Judge, and you have a lot of different factors to consider on that. But of course, that would always be whatever terms you decide. If you grant him a bond, it would be very helpful to have him available to meet with me and speak with me so we could help develop his defense.
Right, so Mr. Morales, I don't take any of this as true because I haven't received anything. But the court's problem is you've picked up allegedly another DWI,
Yes, ma'am.
and that makes it a DWI third because you're here before me for a DWI third.
Yes, ma'am.
So I'm not taking any of it as true, but we did have a previous violation
Yes,
report
ma'am.
where the court ordered ignition interlock and alcohol awareness course.
Yes, ma'am.
And it
And-
appears
Yes.
none of this is helping you. And part of setting bonds and setting conditions, it's for me to make sure that you're successful on bond, but also to protect the community. And it's obvious that I can't, with you, there's nothing I can do to protect the community because there's an allegation that you picked up another DWI. And if you are on ignition interlock for your DWI third and you pick up another DWI, that would mean that you're driving a vehicle that doesn't have ignition interlock on it because normally, unless somebody's figured out a way around the system, if you blow into the ignition interlock and it detects alcohol, your vehicle won't start.
Yes, ma'am. Correct.
So have they changed the way that works?
Amen.
So that would mean if you did have a DWI, one or two things have happened. To be driving, you would need to be in a vehicle that doesn't have ignition interlock. So one, you're violating your bond because you're in a vehicle with no ignition interlock, whether you're drinking alcohol or not.
Yes, ma'am.
That's one problem. Then the other problem is if you are drinking alcohol, again, you're in a vehicle with no ignition interlock. I don't think it's appropriate to have you placed on bond. Now, what I can tell you and what your attorney knows, in order to remand you without bond, there has to be a hearing and the rules of evidence apply. I'm not going to put the state on the spot to do a bond hearing today because I don't think they will be ready. Are you ready with witnesses?
Okay.
They're not ready with witnesses. So if you all want to set a hearing, you can set a bond hearing. The state will have their witnesses here. And then the court will make a decision on whether or not you should be given bond. But as of now, I'm not going to give you a bond because I don't think it's appropriate. All right?
Yes, ma'am.
And I go through all of those explanations so you can make sure that I'm just not doing something just to be doing something or because I have something against you. It's just these are the rules that I'm bound by. And part of it is, even though I don't take any of this as true because I haven't received any evidence, but based on the charges, I have to make sure that the community is protected, okay?
Yes, ma'am.
All right, so counsel, you have all the discovery. State, were you able to tender an offer or no?
I don't know when it's been tendered yet. Your
Okay,
Honor.
and maybe it won't be tendered because you have the another DWI out
Okay.
there. So I'm gonna recall this. Can I have a 30-day reset, please? All right, so you know what? Give me a little bit farther out than June 12th. I'm sorry. All right, we're gonna come back on June 26th. At that time, state, you're to tender an offer.
Yes, sir.
And then if you confer with the state, if you want to have a hearing on your motion to set bond, if you confer with the state and the court, we'll hear it.
Yes, ma'am.
All right, is there anything else?
Nothing further.
All right, thank you.
Thank you, Judge.
Your Honor, Dixon Clinton is out here.
Who's out here?
Dixon Clinton, you asked for him?
Oh, Clinton Dixon, if you'll come forward. Hello. Hi, so your case is being reset for Monday. So your attorney will be here on Monday, okay?
Yes, ma'am.
All right, thank you. All right, who's here on Orlando Medellin? Court is calling two thousand twenty-five CR 3618 State versus Orlando Medellin. Can I have parties announced?
David McLean for the defense.
And are you Mr. Medellin?
Yes, ma'am.
Counsel, have you received all discovery in this case?
I have, Your Honor.
And did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Mr. Medellin, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you understand your charge of collision involving serious bodily injury as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Medellin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. This will run concurrent with 2024 CR 3777. They'll take in consideration 2024 AL 005538. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have you filed any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, community service restitution, substance abuse treatment facility, no contact with the complainants or the addresses. Just one moment. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
The offer states one in attachment.
Your Honor, I've reviewed that with my client. We have no objections.
All right, and with regards to 2024 CR 3777, I'm assuming that's a motion that's already been heard. What is that?
That was a case that the offense date and this case predates that case, but that case was indicted before this case. And so he's already been released on deferred by the court and that on the recommendation of the state of that case as well. And he has conditions for that case as well, and he's also awaiting the treatment that decided in that case.
All right, okay, thank you.
Exactly, Judge.
Let's see. Oh, state, you may be excused, thank you. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor, we'd waive PSI.
Anything you wish to say on behalf of your client?
Your Honor, this case has had some substantial lag in it. As Ms. Galloway just told the court, there was another case that was actually indicted and prosecuted before this case. My client's taken full responsibility for it. his insurance has taken care of the restitution in this matter. There's been a complete settlement and waiver of all claims by the complaining witness. And so my client would just like the court to follow the plea bargain, and ask that he'll be allowed to satisfy his debt to society.
All right, and so here's my question. Which treatment facility is he being sent to?
Looks
Is it
like
Saturday?
status.
Okay. All right, the court is going to sentence you to 7 years deferred adjudication. There's a $2,000 fine that will be probated. This is run concurrent with 2024 CR 3777. Taking consideration 2024 AL 00538. I'm sorry, 5538. He's to be held in custody until transfer to SATA. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Regular random UAs. 200 hours of community service restitution. No contact with the previous stated address and the complainants in this cause number.
One other thing, if I could address the court.
Yes.
Your Honor, I am appointed to Mr. Medellin. We would request, if at all possible, to probate all or at least part of the fine.
I'll probate the fine.
Thank you, Your Honor.
You're welcome. The defensive driving course. Field visits. 1 time per month until further notice, and that's to begin after release from custody. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Yes.
Is that a related condition on the case?
Yes. All right, we can go off the record. Here's the thing, and I've told you this before, so I'm telling it to you again. When people are placed on probation, the state is hoping they'll be successful. Your attorney believes you will be successful. I'm wanting you to be successful. If there's anything that you need help with and you feel you can't address it with probation, or you tried to address it with probation and they're not hearing you, you can always come back to the court to address it with me. Do you understand?
Yes.
All right, good luck to you. You're welcome.
Thank you.
Welcome.
Have a seat, sir.
Yes.
Ross has been my attorney over a year now, and the whole time he's been my attorney, he doesn't contact us, never answers.
Let me stop you right there.
Okay,
Is he a hired attorney?
yes,
All right, so that's something that I don't have any control on it over. All I can do is set it on the docket and.
what's that?
Well, you come back to court and your attorney needs to appear. If your attorney were appointed, there would be other avenues for me to take. So
Okay.
what I'm going to do is I'm going to recall you for Monday.
Okay.
And hopefully your family will get into touch with him and tell him he needs to be here.
Yes, my mom does a very good job of trying to keep in touch with all that stuff for me, but I want to tell you this, I did some motions to fire him.
No.
and then-
Here's the thing. Let's wait till your attorney is here.
Okay,
So we're gonna bring you back on Monday, okay?
all right, and that's
The 19th.
the 19th, Monday. Okay,
All right, we'll see you back then, okay?
okay, appreciate it. I just go this way?
Yes.
Okay, thank you.
Random mob. If you come down, and how do you pronounce your last name? Is it Mab? All right. Court is calling 2025 CR 004527 Stace versus Randall Mab. Can I have parties announced?
James Scott Sullivan for Mr. Mapp.
Jason Gary, stand.
And are you Mr. Mab? Counsel, you received all discovery. Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Mr. Mapp, did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented? Mr. Mapp, did you review the document entitled admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with offense of theft of property, less than $2,500 with 2 or more convictions as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, ma'am.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Both, yes.
Mr. Mapp, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 8 months in the state jail facility and there are no applications. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, it is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yeah.
And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, do you have any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Objection.
All right, state, you may be excused. Did you review the stipulations and waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes. Yes, Your Honor.
Anything you wish to say on behalf of your client?
I'll let my client address the court. Go ahead, buddy.
Yes.
I wanted to ask you, they said that, he said I had to ask you, I was trying to get deferred, so I didn't have a felony.
Well, I want Gretch you deferred on this because it appears that you can't stop stealing. So there's no need, if you don't want to have a felony on your record, you know the easiest way not to have a felony on your record? Don't pick up felonies.
No, he's ready to be sentenced, Your Honor.
All right, the court is finding you guilty. The court is going to sentence you to 8 months in the state jail facility, give you credit for any time served. There's to be no contact with any quick trip. And they spell it in here as QUICKTRIP. And I'll suggest a therapeutic community. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Oh, and I'm sorry, and there's to be no contact with Amanda Vogt, V-O-G-T Martinez. All right, did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you don't have the court's permission to appeal. Because this is a felony conviction, you're not allowed to possess or own any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. How old are you?
36.
All right, 36. And you're out here in the world stealing beer from Quick Trips. Guess what? Quick Trip, these other places that you're committing thefts at, they're trying to run a business. And in running a business, they like for people to pay what they take. So, and you're telling me, I really don't want to have a felony on my record. You are a grown adult. It's not like you're 18 or you're 12 and you keep going into stores taking items that don't belong to you. And you're going to have to sit and ask yourself this question as you're doing your 8 months in jail or at the state jail facility, which is day-to-day time for some beer that costs you $13. You need to ask yourself, is $13.50 worth 8 months of my time in the facility? If you think it is, you'll continue on this path. And at some point in time in Texas, people end up getting shot, getting killed for taking things that don't belong to them. And then you know what people say? They say, oh, well, sorry, that's so sad. And they keep moving. So if you don't want that to be you, you need to stop stealing. All right, good luck to you. All right, Shayna Gonzalez, you say she's on GPS. She's not in custody?
Yes, Judge. And I like to leg monitor.
All right, Norma, have you got in touch with Mr. Michael Bellevue?
No, I have not.
No, I want you to call Mr. Bellevue and let him know that his client is supposed to be in the 187th. And since she's not here, a warrant is going to be issued for her arrest.
I know that my judge, my court appointment has asked me to, limit some stuff. So, like I said, my name is Felipe Reyes. I'm a videographer. I'm from Houston, Texas. And, I'm an immigrant. Sorry.
No problem.
And own a company named Trap Visions.
Mhm.
And I don't know nothing about the judicial system, man. Honestly.
All right, so let me explain
Yeah.
something about the judicial system, okay? And I understand that sometimes people find themselves in situations, they're young, maybe they're doing dumb things. But let me tell you how the legal system works in general, and then I'll tell you how it works in the 187 District Court, okay? So this is what ends up happening. A person gets arrested by the police. Maybe they get arrested, maybe they don't get arrested. Maybe you're just out and about and the police have investigated an offense, but maybe you're not at the scene, right?
Yeah.
So you may end up having a warrant and you don't even know you have a warrant. You're just out and about enjoying your life, and then you get arrested. Now, sometimes you get arrested at the scene. Now, when you're arrested, either if it's at the scene or not at the scene, what ends up happening is there's a process where you get booked. And a magistrate will read you your rights, which will tell you about the right to remain silent. We can have an attorney appointed for you. If you can't afford one will, if you can afford one, you can hire one. And they'll go through this process where they take information from you to see if you qualify for a court-appointed attorney. And they'll tell you can talk to people if you want to talk to the people. And by people, I mean police officers, prosecutors from the state. But if you talk to them, anything that you say may be used against you in a further proceeding. If you have an interview with them, you can stop that interview at any time. So once the police officers do their investigation, if they believe a crime has been committed, you get arrested, a bond gets set, and then that case is sent to the DA's office. They do their discovery on it. Then ultimately you end up in some court. The court you end up in is sort of random. There's some exceptions, like if there's a co-defendant in the court or something, but otherwise it's just a random court you end up in. Then you get appointed an attorney. That attorney looks at the information that the state has. In your case, you're charged with a drug case. So what they look at is they'll look at the police reports. When they look at the police reports, they will look at certain things to make a determination. Hey, is this a stop in a vehicle? If it's a stop in the vehicle, then they want to know, was this a good stop? You know, why did the police pull you over? If it wasn't a situation as that, if police had a search warrant for your arrest, a search warrant for property or something for your home, then what will end up happening is then that attorney will look at that search warrant and see if that search warrant has probable cause in it. Or if there's a arrest warrant, they'll look and see if the arrest warrant is appropriate. So once the attorney does all of that and says, you know what, this stop appears to be great, or this search warrant or this arrest warrant is a good search or arrest warrant, then they start looking at the facts of the case. And they look at the facts of the case by reviewing police reports or whatever the state may have. If this is a drug case, which is it meth? Is it cocaine? Is it heroin? What type of drug that they're saying you possess? And is it an illegal substance, something that you're not allowed to have? Cocaine, marijuana, meth, heroin, right? They'll look at that and they'll see if there's a report in there from a chemist saying, we tested these drugs and it's heroin, meth, cocaine, or whatever it may be. And then they'll look at the chemist so that chemists can say, what's the weight of this drug? So you're charged with manufacturing delivery, penalty group 1, 4 to 200 grams. So he wants to know, is the chemist saying the weight of it is between 4 and 200 grams? If it is, and the chemist is saying, hey, yeah, this is heroin, meth, whatever it may be, then the next thing he will do is, in this court, I require that the defense get an offer. They'll get an offer from the state. And you can either accept the offer, not accept the offer. If you choose not to accept the offer, then what will end up happening is you will have a jury trial. Witnesses will be called by the state. Based upon this, I'm assuming they're going to call the police to come in and say why they ended up arresting you, what they saw, what they heard, things of that nature. Of course, there'll be rules of evidence, hearsay, and that type of thing. They'll call in the chemist. The chemist will say, these are the drugs that were brought to me by the police. I weighed them. This is how much they weigh. I tested them. This is what it came back as. That's it. Normally with drug cases, at least when I was practicing law, the only way to sort of help your client, or I don't want to say help, but the only question really is it a good stop? Is the search warrant good? If the search warrant is good, or if the stop is good, you're pretty much stuck like Chuck a little bit, because it is, are these drugs? Chemist is going to come in and say, these are drugs. The chemist is going to come in and say, this is how much it weighed. The chemist is going to say, yep, this is all I did. And usually the chemists don't have a dog in the fight. They don't know you. Their job is just to get drugs from the police or whatever agency, test it to see what it is, and put in their report, I tested these drugs. This is how much it is. And what I can tell you with chemists, they're not going to measure the full 200. If you're charged with possession with intent 4 to 200 grams, they're not going to test 200 grams. They're just going to test enough to get where it needs to be. If they think it's a lot, they'll test probably about 20 grams, because then you're between the 4 to 200 grams. If it's 1 to 4 grams, they're probably going to test till they get to about 2 grams and a little bit more. And then that's it. And usually there's really nothing to cross the chemist about, unless it's a bad chemist, has some bad things in their past as far as their inability to test and identify drugs. So usually the chemist part is out the window because they don't have a dog in this fight. Then the state will call the police officers in. Your attorney will have a chance to question them. So here are your choices today. You have a plea deadline date. Your plea deadline date was extended. You can either accept this plea, or either you can go to a bench trial or a jury trial. Those are your 3 choices. So 1, do you want to accept the plea? Yes or no? I don't know what the plea is, but do you want to accept it? And if the answer is no, what's going to end up happening? The court will not accept any plea bargaining agreements in this case without good cause. Otherwise, you're going to have to plea open to the court. So first question, have you received an offer from the state?
Yes, ma'am.
Do you want to accept it? Yes or no? State, do you want to give him till Monday?
Judge, I'll leave it open on Monday. I left it out open till today and, well, after rejected it, but I will leave open the.
All right, so here's the thing. Monday is gonna be your last day. And when I
Take
say,
the-
Hmm?
Take the deal.
well, no, here's the thing. I don't want you to be rushed. Are you sure this is what you want to do?
Want to get out in more years if I take it to
No, no,
trial.
no, here's the thing.
Yeah,
What I will do is, they're saying they're gonna keep it open till Monday.
yeah.
We're gonna have you come back on Monday. Your defense attorney is gonna be here at 9 a.m. on Monday.
I'll visit him this weekend.
All right. And then we will bring you over. And if you want to accept the offer, then I'll hear it and I'll go from there. And what I can tell you is when the state presents their evidence to me, even though you're entering a plea of it, I still have to review it and see if the state has proved their case beyond a reasonable doubt. So I'm another person who looks at it, okay?
Yes, ma'am.
All right, so we're gonna bring you back on Monday, and after that, there will be no further extensions.
Appreciate you, ma'am.
All right, thank you.
Thank
Have a
you.
good one.
You
You
too.
too.